Hi folks, welcome. We're going to go ahead and get started. We have some great speakers tonight. I'm going to let them introduce themselves to you, and we'll go ahead and get started. I always tell all the speakers, it's up to you if you want to take questions, if you don't want to wait to the end. However you want to structure it is fine with us.
All right, thanks. All right, thank you. Does it sound okay? Can everybody hear me in the back? Okay. My name is Morris Turk. I'm an attorney here in town. I limit my practice to trademark and copyright matters. I've been practicing for about 13 years now, and my focus has been trademark and copyright. Mostly I work with small and startup businesses to help them protect their names and logos and slogans and characters, all of their trademarks, and that's what we're going to be discussing today. Certainly, if you have any questions, please raise your hand. I'd be happy to answer them. Also, my contact information is on the first slide here, so if you have any questions that you'd like to address outside of this classroom, please feel free to email me or call me, and I'd be glad to discuss those with you. All right, so introduction to trademark and copyright. I'm actually not going to be doing the copyright portion. Annette Heller is going to be doing the copyright portion of this presentation, so I'm going to be just talking about trademarks. So we're going to just talk about intellectual property in general. Intellectual property refers to 4 distinct categories of property. Trademarks. And trademarks are designations used to indicate the source of products or services. And we're going to get into that much more deeply. Copyright. Copyright protects a wide variety of original works. And again, Annette Heller is going to be discussing that. Then we have patents. Patents protect novel and non-obvious inventions for a limited time. And we have another speaker, Scott Smith, who is going to be talking about that. I'm not a patent attorney, so any questions you have about patents, you'll have to wait for Scott. And then we have trade secrets. And trade secrets are basically confidential and commercially valuable information that would be, valuable to your competitors. So great examples would be the Coca-Cola formula or the KFC chicken recipe. But it also can, encompass business methods, budgeting information, cost information, customer and client lists, things like that could give your competitors an edge over you if they knew about it. But again, today we're limiting the talk on trademarks. Now, I did have a little video here, but I don't unfortunately think it's going to work. Oh, it might actually. I take that back. Let's see. So has anybody ever seen Coming to America? Okay, so there's a clip in Coming to America where the main character is interested in this woman, and he wants to try to get a job at a fast food restaurant owned by the love interest's father. And this is a great example of trademark infringement, if I can get the video to play. So let's see. And if there's sound. I don't think there's any sound, unfortunately. That's my second job. Well, you can kind of see it. You won't be able to hear it, but you can kind of see what happens as they're walking into the restaurant. Kind of looks like a McDonald's. If you look in the bottom, if you look right here in the menu, it's the little golden arches there. Unfortunately, I can't play the sound, but what the owner of the restaurant is saying is, they're McDonald's, we're McDowell's. They have the golden arches, we have the golden arcs. They have the Big Mac, we have the Big Mick. And so he's going over all the little differences between his fast food restaurant and McDonald's. It's a very funny scene, but as you can see on the bottom corners of my slide, I think we could all agree that McDonald's with the golden arcs and McDonald's with the golden arches, I think we could agree that those are probably confusingly similar trademarks when used in connection with fast food restaurants. I think we can all agree on that. So that would be considered a trademark infringement. So if you haven't seen that clip, go on YouTube and pull it up. It's very funny.
Question.
Yes.
Who would consider that an infringement?
Well, McDonald's would certainly consider it an infringement, but if it was to go to court, I'm sure a judge or a jury would also consider it to be an infringement. Yes.
when I was living in California, it was kind of notorious at the time. There was this North Face, the clothing and the sportswear, apparel and stuff.
Yes.
And this young college student, he started selling T-shirts and hats called South Butt.
Yeah, I'm familiar with that because I'm the one that filed the trademark application for the South Butt. So I'm very familiar with that. I was not as involved in the litigation between the North Face and the South Butt. That was another attorney, but yeah, I was the one who filed the application and got on North Face's radar. So I know a little bit about it. If you ever want to hear more about the story, I can certainly tell you. But the North Face, we'll never know how that case would have ended up because, you know, the South Butt was claiming, oh, it's a parody, it's just funny, no one's going to be confused. And the North Face was like, no, this is just a straight up infringement, you need to stop. You know, the case settled, it never went to trial, so we don't know how a judge or a jury would have ruled. But certainly reasonable minds could differ on, you know, whether that's an infringement or not. So we'll leave it at that. Okay, so what is a trademark? Well, a trademark can be a name, a logo, a slogan or a tagline, a character, a symbol, a color. So for example, Owens Corning pink insulation, that is the only insulation on the market that is pink. Over time, that color has become a trademark for the Owens Corning Corporation. Also, Kodak, the Kodak company used to use, and they probably still do if you can find it, they used to use a very specific yellow, like a goldenrod yellow almost, for their film boxes and other related camera products. They were the only film company, camera company that used that particular color. And over time, that color became a trademark for Kodak because people would recognize it as belonging to Kodak. Yes?
You say over time, is there a particular amount of time that they have to use that before they become a trademark?
There's no particular time, but there's a presumption in the law that if you've been using it continuously and you've been the substantially exclusive user, the presumption that over 5 years it's become distinctive and it can be considered a trademark. But that's not necessarily true, it could be longer. Yes?
How would you know that a particular color is trademarked? For instance, the Tiffany blue or the Sprint yellow.
You could do a trademark search and find that out. It's not that easy. It's not that easy to do. It's not easy to search a color, like say on the Trademark Office's website. But if you hire an attorney to do that, they have more sophisticated tools that they can use to figure that out. Okay, also sounds can be a trademark. So for example, the NBC chime, ding, 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 that's a trademark. Or the Red Robin restaurant tune, you know, the Red Robin, yum, that's also a sound trademark. Scent. These are pretty rare, but they do come about sometimes. So for example, there was a company that manufactured a certain type of thread that smelled like a particular flower. And over time, that scent became a trademark of that company because people would recognize that particular scent as belonging to that particular thread manufactured by that particular thread company. Also, just recently in the news, I saw that the company that makes Play-Doh, I'm blanking on what that company is, but Hasbro maybe, I'm not sure. Anyway, Hasbro has recently tried to obtain trademark protection for the smell of Play-Doh. And think back to your childhoods, it does have a pretty distinct scent. You know, if we pumped in that scent right now, you'd probably say, oh, that's Play-Doh. So they may be successful in getting trademark protection for that scent. Who knows? We'll find out. Okay, but all of these things need to be used by individuals, businesses, organizations, or associations to identify and distinguish their products and services and to indicate the source of their products and services. If those names and logos and colors and sounds don't do that, it is not a trademark. So, examples of some famous trademarks. We have the Apple logo, Apple icon, very famous. The Ford name, as well as the logo and the stylized font that it's in. The NBC peacock, as well as the acronym NBC. The Facebook icon. The Nike swoosh. The name Coca-Cola, as well as in that sort of distinctive font. The McDonald's Golden Arches and the tagline, I'm loving it. As I talked about, the pink color of the Owens Corning Pink Panther installation. The word Disney, as well as in that very stylized, unique font. And of course, the most famous trademark of all, the one that I use for my law firm, yourtrademarkattorney.com. So every business does have a trademark, even my law firm. So some very famous examples up there. So every business does have a trademark. And consumers use trademarks to identify and compare products and services and to distinguish between products and services. So, for example, if I was to put 2 bottles of dark cola in front of you with no label or anything on the bottle, you would not know, just by looking at the bottle, which one is Coke and which one's Pepsi, or is one Dr. Pepper, or is one root beer, Muggs root beer. Who knows? You can't tell just by looking at the bottle. As you could imagine, it would be chaos in the soda aisle if there was no labels on any of the bottles. You wouldn't know what you were buying. And we need these trademarks to make those comparisons and to distinguish the products. Trademarks also embody the qualities and the characteristics of the products or services with which they're used. So, for example, when you think of the word Coca-Cola, certain attributes might come to mind. Sweet, fizzy, dark, if you like it, tasty. Some people might say fattening or unhealthy. These are all qualities and characteristics that people might think of when they hear the word Coca-Cola. It's all embodied in that trademark. Trademarks also offer consumers assurances of quality and consistency, whether good or bad. So, for example, I'll use Coca-Cola again. This is not an ad for Coca-Cola, just by the way. I'm not sponsored by them. I just think they're a good company to use as an example. So you open up a can of Coca-Cola, you drink it, and you say, oh, it tastes great, it's fizzy, it's sweet, it's great, I love it. And you expect that every time you open a Coca-Cola, it's going to taste the same, smell the same, look the same. And if it doesn't, you are going to question whether you purchased a Coca-Cola. Maybe you accidentally purchased a Pepsi, who knows, or a generic brand. So you expect it to taste the same, look the same, smell the same every time. And if you like the way it tastes, and you like the way it smells, and you like the way it looks, then you are more likely to look for the Coca-Cola trademark in your soda aisle of the grocery store and buy Coca-Cola brand soda again. But let's say you have a bad experience. Let's say you buy a box of Cheez-It brand crackers. You open the box, the crackers are soggy, they are moldy, they're soft, they have a crazy nuclear orange color. Whatever the case is, you look at them, you're like, these are disgusting. You are unlikely to buy the Cheez-It brand cracker again, because you will assume that they will be disgusting every time you open a Cheez-It box. So instead, you will look for a competitor's trademark, Cheese Nip crackers, and you'll buy those instead. Now, trademarks are really a business's most valuable asset because they really embody the goodwill and the reputation of the products as well as of the business and the organization, So, obviously a company like Coca-Cola, they have a lot of assets, right? They have fixtures, they have the Coca-Cola recipe, they have bottling plants, they have inventory, they have all kinds of assets worth billions and billions of dollars. But really, let's say Coca-Cola came up to you and said, hey, I will sell you the Coca-Cola company. I'll sell you everything that the Coca-Cola company has to offer, except for the name Coca-Cola. You cannot use the name Coca-Cola when you start selling your soda. Would you buy it? Probably not. It would be like starting a brand new soda company. It would be like starting from scratch. All the value, or at least most of the value, is wrapped up in the name. So could you imagine if for some reason Coca-Cola had to stop using the name Coca-Cola today? It'd be like starting a brand new soda company. They would lose market share to Pepsi. They'd lose 95% of their market share to Pepsi. Any questions so far?
Do all companies have a trademark?
Yeah, I mean, all businesses have a name, so I would say all businesses have a trademark. They may not be, now it may not be a registered trademark, but but they all have a trademark because they all have a name. Yes?
Recently, Coca-Cola just put out a green label Coca-Cola. And the basic sweetener is the difference between the old Coke and the new Coke. So if they use the word Coca-Cola, but yet it's a different background, are they compelled to make it taste like the old Coke?
I think that's it's not. I don't think it's really I don't think that's really a trademark question. I think people might make assumptions about the way it might taste, but I don't know that that's necessarily a trademark matter. They might want to say something on the label to that effect, but yeah.
So there's no responsibility to use the trademark way it's always been used. So if they wanted to make it an orange soda but call it Coca-Cola, could they still do that?
Of course they could, yeah, because they're the owner of the Coca-Cola name for beverages, and so they could put Coca-Cola on anything they want. In fact, they do put Coca-Cola on a lot of different things, right? They sell T-shirts, they sell keychains, they sell stuffed animals, they sell all kinds of things with the name Coca-Cola. So, yeah.
Just point out as a former employee of Coca-Cola.
Uh-oh. Are you recording this, sir?
They took those flavored sodas and they put them under the Shasta name. They did that purposely for that reason. They didn't know. The other question, are you familiar with Coca-Cola versus Schnucks? It happened here in 1974.
No, that's way before my time.
The essence of it was that Schnucks had snack bars, little restaurants in their stores. And people in St. Louis were in the habit of walking up and they'd say, I want a soda. And the waiter or waitress would say, is Coke all right? And they were serving Pepsi.
Oh, see, that's bad news.
Vice versa, that people would say, oh, I want a Coke. They say, okay, they'd serve them a Pepsi. Well, Coca-Cola was defending their name across the United States. And Schnucks refused to say, now, Coke means cola soda. That was one of the few cases that went to court. Schnucks lost the case. And for that reason, Schnucks decided at that time that since Coca-Cola has such a premium name and value, they were charging 20 cents per six-pack more than they would charge for Pepsi.
Interesting.
And I tell you, Coca-Cola was like, oh, golly, why do you have to say, you're a premium product. You took us to court.
It's funny. Yeah, Coke is obviously very aggressive about defending their trademarks. They're one of the most valuable companies in the world. Yes?
Historical note, I grew up in the South. Everything was Coke.
Right, you want a Coke? It doesn't matter if it's a...
Oh, you might get Dr. Pepper, you might get...
Right. Yeah. Yeah, so... I like how we have so many Coke fans here. All right, two more questions, then I have to move on. Okay?
Yeah, when I worked at Anheuser-Busch, there was some international problem because there was a brewery over in Europe somewhere, Budweiser.
That's right.
Older than Anheuser-Busch.
Yeah, that's been an ongoing trademark dispute for about I sometimes see updates about it, and then they were fighting about European trademarks, not even United States trademarks. And yeah, I think that thing's been going on for like 80 years. It's been crazy.
It doesn't make any difference.
It looks like well, there can be some overlap, but it appears that, let's put it this way, Budweiser's not going to stop using their name here in the United States. And I don't know about the other company in here coming into the United States. I have no idea, but I know that's a trademark dispute that's been going on for many decades. Yes?
How long do you own a trademark for?
Well, I'm going to get to that, but the answer is so long as you're using it.
And that didn't get settled a while back, I think. 80 local laws. The one, the Czechoslovakia or Belgian Budweiser one case.
Yeah, well, maybe in international, maybe not here. You're right, maybe not in the United States, yeah. Yeah, again, I don't know exactly what the details were. Did you have a question, ma'am?
Well, yeah, it was just kind of adding on to his. So what do you do with something like a Kleenex? You know, that's their trademark, but everyone calls it.
Right, well, that's what I call genericide, right? So you basically, it's when people take a trademark and they use it for the generic name of the product. So Kleenex is a great example. People say, I need a Kleenex. Well, Kleenex is a brand name for a tissue. what people are really saying is, I need a tissue. They don't care whether it's Kleenex brand or not, right? I just need a tissue. The same thing is true for like Xerox, right? I'm going to make a Xerox out of that, or I'm going to go Xerox that piece of paper. Xerox is a trademark. What you're saying is, I need a copy. I need to make a copy. There are names out there that were trademarks, but they're no longer trademarks because they have become generic. A good example of that is aspirin. Aspirin used to be a trademark of the Bayer Company. Not anymore. It's become the generic name for that type of medicine. I personally think one trademark that is on the verge of being generic, I think you can make a pretty good argument, is Band-Aid. I mean, everybody says I need a Band-Aid for a bandage, but it's really a Band-Aid brand bandage. So I think that's close. All right, anyway, back to my slides. All right. So a lot of people think that, well, let me ask, has anybody here ever formed a corporation or an LLC with the Missouri Secretary of State or the Illinois Secretary of State or whatever Secretary of State? Okay, so forming a corporation or an LLC does not protect the name of the business. This is a common misconception. It does not protect the name of the business. Forming a corporation or LLC provides limited liability, not trademark protection. So if you're sued, only your corporate assets are at risk, not your personal assets. That's why people make LLCs and corporations. Now, some companies happen to use their legal corporate names as a trademark. So, for example, McDonald's. Their legal corporate name is McDonald's Inc., and everybody knows them as McDonald's. That's their trademark. It's all on their signage. It's all on their products. That's what we know them by. The same is true for Dell Computer, right? The legal corporate name is Dell Inc. or whatever it is. I look at this computer, it says Dell right there. That's the trademark. They're both the same. But some companies don't use their legal corporate name as their trademark. For example, Doctors Associates Inc. Does everybody know who Doctors Associates Inc. is? Subway restaurants. Their legal corporate name is Doctors Associates Inc., but we all know them by their trademark, Subway. What about Homer TLC Inc.? Everybody knows them. In fact, I'm sure somebody here has been in the store in the last 24 hours. No? What's that? Home Depot. Home Depot. So that's their legal corporate name is Homer TLC, but we all know them by their trademark, the Home Depot. So that's why corporate names and trademarks are not the same. They can be same, but they don't have to be the same. Also, if anybody's ever filed a fictitious name registration with the Missouri Secretary of State, that has nothing to do with trademark protection. That is a notice provision. It basically tells the public, hey, I'm ABC Corporation, but I'm doing business as XYZ. So that's a notice provision. You file that fictitious name registration to tell the public, I'm ABC Company, but I'm doing business as XYZ. It gives you no protection for the words XYZ. So I just want everybody to be clear on that. Doing anything with the Missouri Secretary of State does not give you trademark rights.
Does Doctors Associates file a fictitious name doing business as Subway?
Yes, they should. I assume they have. I'm sure they have good lawyers that have told them to do that. All right. Now, how do you acquire trademark rights? You just have to use the trademark. You just have to use it in connection with the advertising and sale of products or services. And you acquire what are called common law trademark rights where the trademark is being used. So, for example, if you are a restaurant and you call yourself the XYZ restaurant and you're in St. Louis and you basically serve St. Louis clientele, then your common law trademark rights will be essentially the St. Louis metropolitan area, but maybe not even the whole St. Louis metropolitan area. Let's say you're located in the city. Well, maybe people from, Lake St. Louis don't come all the way to the city to eat at your restaurant. Maybe you don't advertise out there in Lake St. Louis. So you always have to, it's a very factual inquiry where your common law rights begin and end. But those things can be determined if there's ever a dispute between two parties about who has rights where. Yes?
So that's like Panera and St. Louis Bread Company.
Well, Panera and St. Louis Bread Company are the same company, right? They started as St. Louis Bread Company here in St. Louis. They probably chose a different name like Panera for outside of the St. Louis area because maybe St. Louis Bread Company wasn't that appealing to people who don't live in St. Louis. All right, so common law rights can last forever. And this was the question back there about how long do trademarks last? Trademarks last forever, so long as you're continuing to use them in connection with product and advertising and sale of products and services. That's very different than, as you're going to learn, about patents. Patents are only good for a very limited time, and copyright protection for original works like movies and music, those are only good for a limited time. It's a long time, but it's a limited time.
But you're saying limited, you're saying registered trademarks can last forever.
No, I'm saying, well, a trademark is just a name, a logo, a slogan, right, that you use to advertise and sell products and services, right? Now, that trademark can last forever. Common law rights can last forever so long as you continue to use it. Registered trademarks will last the same amount of time. You just have to renew the federal trademark registration to keep the federal rights. You have to remember, and I'm going to kind of get into it a little bit. I haven't talked about federal registration yet, but federal registration is not the source of trademark rights. That's very different than patent. You don't have a patent until the federal government says you have a patent. That's not true in trademark law. You can acquire trademark rights just by using the trademark. Now, you can enhance. What federal registration does is the United States Patent and Trademark Office issues these registrations. Those registrations acknowledge and enhance the prior acquired common law rights that you got by using the trademark. In the United States, you can't get, generally speaking, you cannot get a trademark registration for a trademark that you are not using. You cannot do that. You must be using a trademark to get a trademark registration. Okay, so a trademark registration is not the source of your trademark rights. The source of your trademark rights is using the trademark for products and services, and as long as that trademark is being used to distinguish between products and services and to indicate the source of the product or service, then you're going to have trademark rights, regardless of whether you have a federal registration or not. The thing about federal registration is that it gives you nationwide rights. So whereas if you don't have a registration, you might only have common law local rights, getting a registration gives you nationwide rights.
Can it be a casual use? Does it have to be, for instance, like if you have a trademark that you're using as a part of a hobby, is that a trademark?
Well, if you're asking whether you have to make money, the answer is no. But if what you're saying is if it's just if it's not a commercial use, or if it's
casually selling a product.
Well, when you say casually, like one a year, I mean, what are you saying?
Maybe 10 or 12 sales a year.
Yeah, I mean, it depends on the kind of product. I mean, there might be products that if you sold 12 in a year, you might make $100 million, right?
But let's say you make $1,000.
That's pretty limited. I don't know if you could support trademark rights for that. That's 12 sales in a year and you made $1,000. It's probably not a lot. You might have trouble enforcing that. Yeah.
You say as long as you stay in business, you can keep it. What if you've gone out of business like a company like Central Hardware? Could I come along and start a new company called Central Hardware?
Generally, the answer is yes, assuming somebody didn't buy the rights and then started using it for like a good example is Sports Authority, right? Sports Authority just went out of business, right? But Dick's Sporting Goods bought the trademarks from Sports Authority. So now what Dick's is going to do probably is use that name Sports Authority for some kind of product line. Maybe they're going to release some kind of sporting goods equipment. Well, if that's the case, then they've retained rights to Sports Authority, and you couldn't go ahead and use Sports Authority for your sporting goods products or services. Yes?
What if you have a trademark that is used worldwide, but it may not be federally registered? Is that, I mean, where's the domain?
Well, I'm not going to talk about worldwide because international trademark it's very complicated, but let's talk about nationwide. Let's say you have a trademark that's nationwide, okay? Well, let's take something like Facebook, right? Facebook, let's pretend that Facebook did not have a federal registration. Of course they do because they're a huge company. Well, certainly Facebook has become so well known, so famous, hundreds of millions of users. Their common law rights extend everywhere. Their common law rights are throughout the nation. They don't even need a federal registration at that point. They're so huge, right? So they still get some other benefits and protections for having the registration. But yeah, their common law trademark rights are nationwide. They are nationwide. But most businesses can't claim that. Like even if you operate, say, on Amazon, you sell products on Amazon. Now you might have some sales in Utah, and you might have some sales in Nevada, and you might have some sales in New York, but having some sporadic sales in some of these different states is not going to give you necessarily common law rights all throughout those states. Again, it's a very factual inquiry. How many sales did you have? How often were there sales made? Was it just in one city in that state, or was it throughout the state? These are things you need to look at to determine where your common law rights begin and end. Okay, now we're going to talk about, and I got about 15 minutes, so why would you perform a trademark search? So you've come up with this name, you love it, you think it's great. How do you know that you can use it? Okay, well, you're going to perform a trademark search because you don't want to be sued for trademark infringement. You don't want to be the McDowells of the world, right? You don't want to risk losing the goodwill and public recognition associated with the trademarks. So for example, like I said about Coca-Cola, could you imagine if Coca-Cola had to change their name tomorrow? All that reputation, all the goodwill, all the public recognition, gone. Gone in an instant. You don't want to spend time and money and resources developing a trademark that isn't available. You don't want to go to your sign store and say, hey, make me this great sign for $40,000, put it up on your store, and then all of a sudden 3 weeks later you get a nasty gram from your competitor saying, hey, I was using that trademark before you. You have a $40,000 sign, which is pretty much good for nothing. You've invested time and money and resources into something that isn't available. You also would do a trademark search to find out whether your trademark is eligible for federal registration with the United States Patent and Trademark Office. Now, there are basically 3 types of trademark searches. There's the common law trademark search. That reveals trademarks that are being used but have never been registered. All right, so trademarks that are just being used. Some restaurant in Omaha, Nebraska, who's never registered their name, but they've got a restaurant, ongoing business, and they call it XYZ Restaurant. They have common law rights, and a common law trademark search might reveal that if you were looking for restaurants under that name. The common law trademark search, though, is the most complicated trademark search to do. It's also the most expensive search to do if you were to have a professional common law search done by a trademark search company that provides those services. Of course, with the internet, you can sort of do a basic common law search. You can go on Google and Bing and some of these other online business directories and do a little common law search yourself, and I would recommend you do that. But don't consider that a comprehensive common law search. Then we have the state trademark search. The state trademark search reveals trademarks that are registered at the state level. Every state, usually with the Secretary of State, they have a trademark registry where you can register a trademark that will give you rights throughout the state. So your common law rights are extended, say, from St. Louis. Now it's all the way throughout the state. I generally don't even recommend state trademark searches anymore. Most people register at the federal level now. Plus, the state registration databases are so out of date. You could do a search on. You can't even search the Missouri Secretary of State's trademark registry online. But attorneys have software that can do it. And you'll see, like on the bottom, where how up to date the records are. They could be 3 or 4 months out of date, and some states are much more out of date than that. Also, there's really at the state level there isn't a lot of scrutiny on the applications that are filed. Basically, if you check all the right boxes and submit the filing fee, you'll get your state trademark registration. So I don't think they're really worth the paper they're printed on, personally. And I think less and less people are even filing at the state level. So I don't even recommend these searches anymore to anybody. Now, the federal trademark search is where all the action is, okay? This reveals trademarks that are registered with the United States Patent and Trademark Office, and it tells us whether somebody has nationwide rights to use a specific trademark for certain products and services. And this is recommended in all cases. Excuse me. The good news is that this is the cheapest and easiest search to do. You can even do a preliminary knockout search yourself by going to the Trademark Office's website and doing what I call a knockout search at that address there. And you can type in the name and see what comes up. Now, this is not a comprehensive federal trademark search. This is a cursory knockout search. Because obviously, if you type in your name, you get a direct hit for very similar products or services. You don't need to go to an attorney to tell you the exact same thing that you found yourself. That'll be a waste of money. Now, if you do this little cursory knockout search online at the USPTO website and you find an obvious conflict, well, you're probably going to want to go back to the drawing board, especially if this is a name that you haven't really started using yet. You know, you're going to say, okay, I better not use that. I better not apply to register that. You know, I don't want to be the McDonald's of the world. And then you maybe go back to the drawing board, think of a new name, and then you could do another knockout search. All right. Go ahead.
What if you want to use your last name for a business, and it's your name, but maybe there's another company out there?
It's a good question. But let's pretend that you want to start a car company, and your last name was Ford. Do you think you could do it? Okay, so the answer depends. If somebody already has trademark rights to a last name, to a surname, that is for very specific products or services, then yes, you would be barred from using your last name for those kinds of products or services. But you can certainly use surnames as a trademark, and they can be registered. They can be protected federally. So the answer is sometimes. You can use your surname. Okay, yes?
Will this only find names? Because before you mentioned sounds and colors and scents. How do you find whether there's any conflict there?
Very difficult. You probably, on the Trademark Office's website, it would be very difficult for just a member of the general public to find is a certain color registered for a certain product, or is a certain sound registered for a certain product or service. Most attorneys have other software that can find those things, but we pay a subscription fee, and it's all software-based. It's a Boolean search thing. So unfortunately, if you wanted to find that out, you probably would need to hire an attorney or a trademark search company to find that out. Yes?
If you were going to start a fast food restaurant named Ford, would that be allowed?
Again, it depends. So trademark, very famous trademarks, I would consider Ford to be one of those, get a special protection called trademark dilution protection. Trademark dilution protection basically says, look, this trademark is so famous, so well known, that you can't use it for any product or service, even if people wouldn't be confused. Even if the products and services are so unrelated that nobody would be confused, you still can't use it. That's why there's only like one Nike in the world, one Xerox in the world, you know?
Apple.
Well, Apple's different, right? Because there's Apple Vacations, there's Apple Records, there's Apple Computer. So Apple's a little bit different. But certainly you couldn't use Apple for electronics or computers or mobile devices or anything like that. One more question, and then I have to move forward.
Pharmaceutical companies are famous for banking names. I'm not sure whether they do it under trademark or they do it under patent, but they'll bank names, and supposedly competitors can't use those names if they go into either patent or trademark.
Well, you would be talking about trademark. I don't know. I mean, obviously, in the United States, you cannot get a trademark registration or get trademark rights for a name that you're not using. Now, you might be able to reserve a name for a little while. You might be able to kind of reserve it for up to 3 or 4 years. But at the end of the day, if you can't show use of the mark, you will not get a registration. So it's something to consider.
Their names anyway.
Yeah. Well, yeah. So let's say you're doing your search on the Trademark Office's website. You don't find any obvious conflicts. You might consider hiring a trademark attorney to perform a more comprehensive federal search and give you an opinion as to whether your trademark is available for the use and registration. And if we get positive search results, then we might consider looking into federally registering the trademark. Why would you federally register a trademark? Well, like I said, it gives you the exclusive right to use the trademark throughout the United States. It expands your common law rights. It prevents the registration of confusingly similar trademarks by perhaps competitors. You get certain advantages in trademark infringement litigation if you're ever sued by somebody or if you have to sue somebody. It puts the world on constructive notice of your trademark rights, meaning that if somebody wanted to find out whether your trademark was registered, all they'd have to do is go on the Trademark Office's website and search it. They could find out. So it's called constructive notice. It can prevent the importation of infringing products. You can register your trademark registration with the Customs and Border Enforcement, and that will help prevent the importation of products that might have your trademark on them. It can be easier and cheaper to obtain trademark protection in foreign countries, some foreign countries. You can obtain cancellation of infringing domain names. So let's say your trademark is XYZ and somebody registers xyz.com. You might be able to obtain that infringing domain name. And you get the ability to use that little circle R designation when the trademark is actually registered, as opposed to just the little TM that you sometimes see next to product names or service names. So those are the primary reasons why you might choose to federally register a trademark. I'm not going to go through the trademark registration process. It's just we don't have time. But if you did want to talk about the process, feel free to email me or call me. We can talk a little bit more about how the process works. But I do want to go over some trademark advice and tips to end this presentation. Here are some things you should do. You want to conduct a comprehensive federal trademark search prior to adopting a new name or a new tagline. Make sure you're not stepping on anybody's toes. You want to consider federally registering your most valuable trademarks. Again, use a TM if the trademark is unregistered, or a circle R if it is, in fact, federally registered. You want to purchase domain names that incorporate your primary trademarks, like Nike.com, Nike.org, Nike.net. Because if you don't, one of your competitors might. Some other tips. You want to reserve usernames on social media that incorporate your primary trademarks, like on Facebook and Twitter and YouTube and other social media sites. And that's free to do. It doesn't cost anything. Google Alerts is a cool little tool. You can tell Google, hey, send me an email anytime on the internet my trademark is mentioned. So every time XYZ is mentioned on the internet, send me an email and show me where it's being mentioned. This is a great way of tracking what is being said about you or your brand. It's also a good way to keep tabs on your competitors. You could say, if you were Coke, you may set up a Google alert saying, let me know when someone's posting something about Pepsi. So you can kind of track your competitors. And if somebody like me, I have a Google alert for my own name, so I look to see if somebody's posting something about me. Good things, of course. All right. You want to periodically perform a Google search and federal trademark search to check for possible infringements. When I say periodically, I don't mean every day or every week. I mean once a year. Check, see what's going on. See, do a quick cursory search on the Trademark Office's website. See if something was filed that might be of interest to you or might be concerning to you for some reason. You might want to consider hiring a trademark monitoring company. They will monitor the trademark records for you and let you know if something's filed that meets certain criteria that you tell the company about. So if you want to know every trademark that has the word jump in it that's filed, trademark monitoring company will be able to tell you that. Here are some don'ts. Don't purchase domain names or social media usernames that incorporate your competitors' trademarks. That's a very good way of getting sued. Don't adopt, use, or attempt to register your competitors' trademarks. Again, another great way of being sued. Never send cease and desist notices without knowing all the facts. People think that they have a trademark registration, they think they're invincible. I have a trademark registration, okay? That doesn't mean anything, okay? It is possible that you have a trademark registration that isn't worth the paper it's printed on. That is possible. What if somebody was using a trademark for many, many, many years before you got your registration? You send them a cease and desist notice, in return they send you a lawsuit for trademark infringement. Never, ever send a cease and desist notice without knowing all the facts. Don't ever attempt to create a false association or affiliation with a competitor. Again, you never want to make you look like you're sponsored by a competitor or affiliated with some other business that is not you. And finally, don't ever adopt clip art or artwork found on the internet as a trademark or as a logo. Again, you don't know who owns that artwork. It could be owned by somebody else. It's certainly not owned by you. So it's better to, if you want to have a logo, it's better to contact a graphic designer and have them design a logo for you. That way you know it's yours and unique and you don't have to worry about it. You never want to adopt or use or attempt to register a trademark that would dilute the distinctive quality of a famous trademark. That's why I was talking about trademark dilution, right? So you can't adopt the word Nike for any product or service. None. You never want to forget federal trademark registration renewal deadlines. Trademark registrations, even though trademarks last forever so long as you're using them, federal trademark registrations do not last forever. Trademark registrations need to be renewed periodically, and if you forget those deadlines, then your registration will lapse, and you'll be back to having common law rights rather than the rights associated with federal trademark registration. And never ever rely on the results of a federal trademark search performed on the Trademark Office's website. Again, what you can do on that website is a cursory knockout search. It is not comprehensive, and you cannot rely on the results, but it's a good place to start.
Well, how long is the registered trademark?
A trademark registration needs to be renewed between the 5th and the 6th year of registration, and then again between the 9th and the 10th year of registration, and then every 10 years after that. Some other quick notes, I got 1 minute. Don't delay registering your most valuable trademarks, because if you do, it can become very expensive to register your mark. If somebody else has registered a similar mark before you, it might even be impossible to register your mark if you wait too long. So don't delay. Don't ever present false or misleading information in your trademark application, either purposely or accidentally. That will essentially make your registration not worth the paper it's printed on. So it's very important to make sure that everything in your application is factually accurate. Never ignore or take lightly allegations of trademark infringement. You might be using a trademark, you've been maybe using it for a few years, all of a sudden you get a letter in the mail saying, hey, from a lawyer, it sounds pretty mean, like we are, and it says, hey, you have to stop using the trademark. You're infringing on my client's rights. Well, the worst thing you can do is crumple up that piece of paper and throw it in the trash, because what could maybe be resolved very easily and very cheaply then turns into thousands of dollars in litigation costs. So don't take them lightly. Don't ignore them. Go to an attorney and see what can be done about the situation. And also, you might have heard of services like LegalZoom that do a lot of what we call document preparation services. There's also something called Trademarkia. They're also known as LegalForce. They do very, very cheap, very inexpensive trademark services. Obviously, I'm not a big fan of these kinds of services. I think they do a very poor job. But let me tell you, trademark registration, you don't need a lawyer to do it. It's not legally required to have a lawyer to do it. In fact, many, many people do it themselves. So let me say this. Save yourself the $99 that Trademarkia and LegalZoom will charge and go straight to the Trademark Office's website and do it yourself. If you're not going to use an attorney, that's fine. That's your choice. But do not use one of these services. They're not offering anything that is not freely available on the Trademark Office's website. Nothing. Okay, so that's my 2 cents. I'll save you $99. All right, that's it. Thank you very much.
Not a patent attorney. My background is in business. I have an undergraduate degree in marketing, business, and then, of course, a law degree. Trademarks, copyrights are very business-oriented areas of intellectual property, as patents is too. But patent attorneys, as they will explain to you, have an entirely different background than us trademark copyright attorneys. So this is the other aspect of intellectual property, copyrights, that Morris mentioned, that we're going to be talking about for the next 25 minutes. Again, if you have questions while I'm talking, just raise your hand and let's try to get them answered, because I'm here to answer your questions, not to just lecture to you about copyright law. Copyright law is in the Constitution and is one of the elements that most people are familiar with. What does copyright protect? It protects original expressions of authorships fixed in a tangible medium of expression. It's a legal definition. Basically, if you create something, you own it under copyright law. You are the creator, you make a painting, you write a book, you write music, you are the author and you are the creator of the work. It's original work of authorship. Now that original authorship is sometimes very limited. Somebody else will ask me, well, how much of something can I copy and not be infringing a copyrighted work? Well, some copyrighted works, only 1% of it is really protected. Another copyrighted work might be 90%. So it depends on how much of originality is in that work as to what is actually protected. As it says, some intellectual labor, it has a low standard as to what is copyrightable. Because a lot of people can do the same thing as long as it's their original work. They haven't copied it from somebody else. You come up with an idea and you go out and take a picture of the arch when the sun is coming up, and you sit there and you take your camera and you take that photograph. You have a copyrighted piece of work. Someone could be standing next to you doing the same thing, and they will have copyright rights to their picture. Basically the same picture, taken at the same time, the same place. But each party owns their own rights to that copyrighted work.
Who determines the originality?
Who determines it?
Yeah.
Well, in litigation, it would be a court based upon facts. But if you created it and you didn't copy it from somebody else, then it's original work.
So if nobody challenges you, then it's yours.
That's right. As long as it's not challenged. Two people can come up with the same created work. And sometimes it's because you might have seen something 10 years before. There's two elements, and we'll get into this a little later. It's access and substantial copying, and what is being copied. Because if it's material that's basically what we call public domain, or not really copyrightable work, then you have no protection on it. It's a tangible medium expression, and it includes a lot of things. A lot of things you're familiar with: books, drawings, music, computer programs. That's probably, in the last 50 years, one of the more common copyrighted works. Something that you probably don't see very often, or you see every day and don't even think about. We're all familiar with the Rice Krispies box, right? Well, this is a copyrighted piece of work. And it has trademarks on it. It has your Kellogg's, which is your house mark, Rice Krispies, which is your brand name for the product. You have the characters on there, and you have the characters' names, and you have text. You have recipes. This is all copyrighted work. My career started with Ralston Purina, and I was in-house trademark copyright attorney. One of their packaging on the back was kitchen chow, and it had the growing cats for the kittens, and it was on the back of the packaging. Another disco club took those pictures of the cats and was using it in their advertising. We became aware of it when a consumer wrote us and said, how could you be involved with a disco club and using your cats? Of course, we sent them a cease and desist letter, and they stopped using our copyrighted cats. Again, that's how we protect the various elements. But those are the types of items that are expressed. It's an expression. Copyright does not protect ideas. It's the expression of the idea that's protected. So if you come up with the idea of going out and taking a picture of the arch and the sun coming up, that's not protectable. You can't prevent other people from doing it. You only protect your picture of it as that sun is coming up. Somebody can't take your picture and put it on a t-shirt. That would not be permitted. If they went and took their own picture and put it on a t-shirt, yes, they could do that. But they could not take your picture and put it on the t-shirt. They have to be affixed in a tangible form of expression. Copyright also does not protect methods, concepts, discoveries or investments, names, titles, slogans, or quotes. Those are things that are not protected by copyright. Again, copyright is protected by the act of creation. Again, like in trademarks, you had the common law rights that you could acquire by using it. Copyright is by the act of creation. You register your copyright to enforce your rights. So if you have created a book, wrote a book, and you want to send it to publishers for publication, you will want to register that manuscript as an unpublished work, just in case one of those book publishers takes your work and tries to pass it off on their own. You will have the legal right to go after them. But without the copyright registration, you don't have access to our federal courts. Yes?
Does a copyright not protect inventions because that is protected, those are protected by patent?
That's correct.
So it's really like the written word that you thought of that is protected by copyright?
Correct. Are the drawings, our photographs, our computer programs, dances, music, those are all copyrighted works.
I went to a department store one time and had my picture taken.
Mm-hmm.
And they offered me prices where if I could buy my picture and I could use it personally, but if I got hired for a job or used it on the resume or got hired as a model or I had an acting career or anything and those pictures were used in that way, then they took a percentage of what I earned, or else I could buy the copyright or whatever it was that I was buying and I could use pictures any way I wanted.
Well, yes, that's correct. And we'll get into that, but let me cover it now because we're on limited time and we may not get to that. The person who took the picture owns the copyright. They can limit where you use that photograph. Just because you have physical possession of the photograph does not allow you to do anything with it other than put it on display in your home. If you want to make copies of it, you have to get permission from the photographer. If you want to distribute copies of it, you want to get permission from the photographer, because the photographer is the one that took the picture. Now, a copyright owner can transfer their rights to another party. So, if that photographer said, you can have all the copyright rights to this photograph for so much money, then, and you pay it, and they transfer those rights. They give you a written piece of paper, and you have to have it in writing. I hereby transfer all rights to this photograph to John Smith. All copyright rights.
Has it always been that way?
It has always been that way. A lot of people believe they pay for the work, they own it. That's not true under copyright law. You're paying for the right to use it for whatever purpose it was done by contract. You don't own it unless you get in writing a transfer of the copyright rights from that work to you.
That's only if they make a point of saying that they own the copyright.
No, they own the copyright by the act of creation.
I mean, they take my picture, and most places won't do that, only professional photographers.
That's right, they don't do it, and that's their choice. But if they want to enforce it,
a year down the road,
they could do that, yes. And it comes to play more in the area of photographs that are done for brochures or catalogs by a photographer in a business relationship. People think, well, I paid the photographer to take all these pictures, I own it. And then let's say they sell the business. And I had a case like this many years ago. Photographer never transferred his copyright rights to the photographs to that company. The company got sold to another party. They didn't want to use him anymore. So we sent him a letter and said, you can't use all these old photographs anymore. And of course, we came to a compromise, and they paid him to have the rights transferred. So if you're in a business and you're doing copyrighted work, you have to realize that you have to get it in writing up front. You work up front and say, okay, I'm going to pay you XYZ for doing these photographs, and you're going to transfer all rights to those photographs to me. And you put it in writing.
It's really not my picture.
Pardon?
It's not really my picture.
It's not your picture. You only have the physical. It's like an artist who paints a picture. He owns that copyright. You're buying the physical possession of it. You can't make copies from it without the artist's permission.
If you're teaching a class and say you copy out a Thomas Friedman novel, you pass it out to the class, is that fair use? Is that...
Well, again, it depends on how much are you taking the place of they're going to buy the book to use in the class?
One of his columns.
In an educational, there are educational exceptions in the copyright law that allows you to make copies of certain things, and a limited number copyright.
I have a question regarding videoing a concert.
Pardon?
If a concert is being videoed, say, by someone in the audience, and it shows up on YouTube, who does that belong to?
Well, the performance is a copyrighted work. And the person who photographed it, who published it, is infringing your copyright rights to the performance. Now, the person who took the video and somebody copies that person's video, then they're infringing that party's video of the work. Let's say you paid a person to come and video the performance, and they put it up on YouTube. And that was the agreement you had with the cameraman. Somebody else takes that YouTube video and plugs it into a commercial. Well, that's an infringement of both your rights as a performance and, of course, the videographer's rights to the video itself.
But if it's not a professional videographer, it's just someone takes the videos of the concert and then puts it up on YouTube.
You could tell them to take it down because there was not an authorized copy made of the performance, because the performance itself is a copyrighted work. Dance routines are copyrighted work. And I'm kind of getting away from the program here because we do cover that, but dances are copyrighted work. Plays, the performance of a play is a copyrighted work. And that's why they tell you when you go into a play, you cannot take photographs, you can't, make any videos from it, because you're infringing their copyright rights.
I just wanted some clarification. If you're an artist, a photographer, say, and do you have to get a copyright? Can you get like a general copyright for all your work, or do you have to get each piece of work copyright?
Again, it depends on the type of work. Magazines can get serial copyrights. Photographers sometimes take all of it used to be negatives, and now they could put it on a flash drive and register everything at the end of the year as a bulk copyrighted work. There are ways, and the only reason you register a work is to be able to enforce your copyright. And that's in the United States. Outside the United States, you don't have to have a registration in many countries to enforce your rights. But in the United States, to get into court to enforce your copyright, you have to have a registration. And you can get that registration after the infringement, but some of your rights are limited in your recovery.
This movie you showed, Coming to America, they put it out, and somebody sued him for several $1 million. He had no copyright. He claimed, I gave you my 30-minute spiel on this movie, and you made it, and you owe me money, and he won. He had no restoration for it, though.
Well, sometimes, you don't, he had to have a registration to get into court. And you can get a registration after the infringement.
Oh, okay.
You don't have to get it right away. You can get it after infringement. It just limits some of your ability to recover certain things in a copyright lawsuit. But there's two elements you have to have, and it's quite a ways into this. Let's see, where is it? Well, that protects you from the consent. Reproduce, these are the rights that you have. Reproducing the work, displaying the work, performing the work, distributing the work, using the work to make derivative works. That is, if you write a book and somebody makes a movie from it, that would be a derivative work.
How about a parody? Do parodies fall under the derivative work? Like
parody is a except. Well, that has its own copyrighted to it. But if it's a parody under the copyright law, you can use so much of the original work to make the parody work. And it's allowed under the copyright law. Yes, sir.
Is there a sunset to copyright law? Or to a copyright?
Yes, there is. You do have a certain number of years. For an individual, and it's later on in here, I think it's 70 years now. For a corporation, it's 90 years, and then it goes into public domain. And that's since 76. Prior to that, the law was different. So some things are in the, and prior to 1989, if you didn't have a copyright symbol on it, your work automatically went into the public domain. So copyright law is not a clear-cut issue when it comes to what is copyrighted and what's not. Sometimes you have to do some research to find out. I had a client who had brought in a catalog that he wanted to reproduce, and it was a catalog from the 1940s. It had a copyright notice on it. Well, we did research. We went to the Copyright Office and had some research done. It had not been renewed. Under the prior law, prior to 1976, you had a 25-year period, and then you had to renew it to get another, it's 28 years to get another 28 years. It had not been renewed. So he was able to reproduce it because it was in the public domain. But he had no rights to it because it wasn't his work. The only rights he had was he put in an introduction to it, and that gave him the right to put his own copyright notice on it. To someone who might not be familiar with copyright would have think the whole thing was his. But really the only protected part was his introduction. Yes?
If, let's say you wanted to make a picture and you wanted to create something original, like, and you saw somewhere a tree, and you liked that tree, so you put that tree in your picture, and on a few other pictures you like this or like that, and you put them all together in one picture. Are you infringing all those copyrights, or does it become an original work?
It may become original work, but are you taking the tree from another picture and putting it in yours, or you like that type of tree and you just found a unprotected picture of that tree and incorporated in your work?
If you took pretty much the exact tree, but that was only one part of their big picture.
It probably wouldn't be. Again, how much of the work has been taken to be an infringement is another, it's a fact issue when you look at an infringement issue. But generally, if you're pretty much creating your own work, and it's a composite of a lot of different things, the odds are that you're not infringing anybody's copyright. But these are the 5 rights you have. You can transfer all of the rights or part of the rights. In the music industry, the performing music has been transferred to a couple societies, BMI, ASCAP. Composers, they don't want to go out enforcing their rights of their music. They've transferred their rights to one of these societies who enforce it, and then they get their royalties from that. It's not an all or nothing transfer. You can say, okay, I will give you the right to display my work. I will give you the right to reproduce my work. You can give 5 different people 5 different rights to that work. Yes, sir?
BMI, you just said the word BMI. Is that a real entity?
A real what?
Company?
Yes, it's a professional society that is composed of authors, of music writers who enforce their copyrighted work.
I own a bar, and they came in, knocked on my door, and said, "You can't have karaoke can't have a band, you can't have, unless you pay a royalty to BMI. So that is in fact correct.
That's correct.
It's almost like buying a store.
And ASCAP will also come in, and because they represent different people.
Really?
Unless you decide, okay, I'm only going to do BMI society members, and you can get a list of them from them and only use their works, then you only have to pay BMI. But you have to remember, these people spent time writing music. They want to be paid for it. And if you're performing their work, you're doing it because it's going to enhance your bar so that people will be there. You're earning money from it. They should be able to earn money from it. Somebody way back there.
Oh, I'm sorry. My question is just if you are a wedding photographer, for example, and you take pictures of somebody's wedding, do you need to copyright those pictures before you transfer the copyright to that married couple, or do you just transfer your copyright in a written statement?
If you're a wedding photographer, you can transfer your rights to the pictures to the party who's paying for it. And they can then make as many copies of all the pictures they want. If they don't transfer their rights, then you can only have the book of pictures that you selected and paid for. You cannot make copies from them.
But like the photographer wouldn't have to copyright those pictures before they transfer them. They wouldn't have
They're already copyrighted. They're copyrighted by the act of creation.
they wouldn't have to do the copyright
Registration? Yeah, and they probably would never do it.
Right.
Registration is to enforce your copyright. And, we advise clients to, register works that are going to, you spent a lot of money developing. And you say, oh, well, who's going to copy my brochure that's talking about my business or my products? Well, as doctors see the worst case scenario when it comes to diseases and illness, lawyers see the worst case scenarios. And I had a client who had a brochure developed, spent a couple $1,000s having it done. And another person copied every single thing except the name of the company and changed it. That's a copyright infringement. I had another case of a well-known artist here in St. Louis. They took one of his pictures and put it on top of a cover of their brochure without asking his permission. They had the original artwork. They thought they could photograph it and put it on their brochure. It's a copyright infringement. I really don't have much more time, but let's see. Everyone has a copy of all these slides, right? So if you kind of look through this and see if there's any questions you might have, because I'm not going to be able to get through these in the next 5 minutes, because we do have your patent section, and we're supposed to be out by 9, so we'll want to go to the patent section right after this. So would you take a minute and look through there and see if you have any questions, because I know I'm not going to get through all of this.
What do you need, like I mentioned the case where he took him to court for that movie. What did he need in order to register after the fact?
He needed to show access to his work, and it had to show substantial copying to be copyright infringement. So if a person never had access, and that's the first element, never had access to your work, and just because they came up with the same idea doesn't mean that there's copyright infringement. Right, it's access. That's the important thing. So that's why if you're going to send something to somebody else, you want to have some communication with them beforehand. Are you interested in seeing my script? Are you interested in seeing my ideas for a new advertising program? And if they say yes, then you have some proof of their having access to your work. So you would go from there. Yes?
Are data sets included in copyright law, or
Pardon?
Can you take a data set from a report or something and use it for your own report and distribute it, or would that be an infringement?
Data, unless it's originally created data, itself is not copyrightable because they're just facts. So facts tend to, be able to be used for other purposes. There's a question back there?
Yeah,
I'm looking for like a picture of a butterfly, put on a poster in your yard. And you just Google butterfly, and you find something you like, and you print it off, and it's going out to put it as a poster in your yard. Is that happening? You have no idea whose picture it is.
Again, you take something off the internet, you may be infringing somebody else's rights. There's a lot of stuff on the internet that, well, I should say everything on the internet is owned by somebody, and somebody may have reproduced it a dozen times. Getty is a company that goes after people who take pictures off the internet and send cease and desist letter, and we have clients who get those letters, and you're talking thousands of dollars that they're asking for the use of those. So if you're going to do a brochure, you're going to do a poster, your best bet is to get a designer to do what you want and get the copyright rights to it so you can do whatever you want with it. Yes, sir.
I'm looking at one of the slides here. This is under copyright advice and tips. Continue. It says, do use indemnification agreements with independent contractors who develop creative works on your behalf. Would you explain this indemnification agreement? What's that?
Indemnification is they say they have not infringed somebody else's work.
So the photographer that you hired, the person that the company hired to develop something, they didn't go to the internet and copy something.
That's correct. Because if they did, and you have an indemnification in that contract, then you go back after them for the copyright infringement. I'm going to have to turn it over to Scott, so you get a half an hour on this. Are you mic'd? I will be here for a little bit if you have some questions. Sorry, I have a program that was a little longer than I thought it would be.
Okay, well, if you're ready, I'll get started. Welcome. This is the grand finale of intellectual property. I'll try to keep it quick so we can get to your questions. You can interrupt, of course, if you got questions along the way. I work for a patent law firm in town. I've been practicing for 14 years. I've done patents with everybody from independent inventors to Fortune 500 companies. So hopefully I'll be able to answer all your questions. It's all very different depending on who the client is. But let's talk about where does this come from? Intellectual property is one of the few things that actually is directly cited in the Constitution. That makes it kind of a special area law. There isn't an area law in there about, say, contracts. Of course, we have contracts, but this kind of makes it special. It was actually put there by the founders because they thought it was such an important area of law. The reason for this, the philosophy, there's kind of two reasons for all three of these: trademarks, copyrights, and patents. One was what they called natural law, meaning that you have a right to profit from the fruits of your own labor. Everybody that's sort of obvious to most of us when you think about building an actual object. Intellectual property, the easy way to try to understand is it's just intangible. It's just like the real objects you build. You're building ideas here, and it's sort of protected the same way. Again, these are the property rights for intangible assets. None of these things are really the same or equal. They're just different versions of law that you can cover different things. So depending on what your company is, and I'm just kind of trying to wrap this all together so you kind of see that patents cover one thing, trademarks another, copyrights, and trade secrets. One company may have one or all of these things. You can even have one product that might be covering using these different things. They kind of overlap sometimes. They make your company and your products more valuable. And everybody knows there's all sorts of companies out there with trade. These are examples of trademarks. A lot of these are St. Louis examples. In fact, all of these are St. Louis examples. And the reason, of course, you're going to do this is for profit. You can do it for charity as well, but most people are going to use these to profit. You can sell things. You can license things to make a profit. You might work with somebody, a joint venture. All those things are going to be enhanced by the use of intellectual property. But why do we get these now? It's become more and more important, but why? Why is it? One reason it's gotten so important is because the world has gotten to be such a smaller place than it used to be. It's so much easier to go national and global, right? Start a company, even if you're just working out of your house, you're on the internet, you're nationwide, you're worldwide already. That's very different from the way things were 50 years ago when you were going to be limited to doing your business somewhere in your backyard, or if you had to start a distribution business. Now you can be worldwide overnight. The other driving factor is it's so easy to copy these days. And that was talking about online, right? I think about when I was a kid and all we had were, cassette tapes and things like that. They really didn't care as much about copies at that point because they knew my copy eventually was going to wear out. I was going to have to buy another one, or I could lose it. Well, now, digital, you can make infinite amounts of copies, exact copies of things, and they can't stop you except using the law. So that makes this very, very important. And that's more copyright, but we're talking about patents now. But everybody knows about the term, Chinese copy, which is very true. A lot of manufacturers know that people can take their products, take it over to a manufacturer in China or another country, they'll reverse engineer it and start selling a cheaper version of your product. So patents become very, very important to try to protect those kind of problems. Here's just a little chart. You can see just in the past 20 years how important patent protection has become. These are the number of patents that are issuing in the United States every year. In the last 20 years, it just has skyrocketed. It's gone up from here too. This is about 10 years old. So this is what a patent looks like. Other than this, I think this is about the most expensive document that I know of other than a college diploma. A patent these days may run you somewhere around, depending on what it is, and somewhere around $10,000 to $20,000 by the time it's all said and done. So it may sound like a lot, and it can be, especially for independent inventors, but if you're talking about a product that's going to make millions of dollars, obviously that kind of changes things. And
who establishes that price, that cost?
The patent office has fees for it. And then
on the value of whatever the product?
No. Nope. It is strictly the cost associated with the patent office and then the attorneys that draft the document for you.
And just out of curiosity, attorneys, they charge what, $250 an hour?
It depends. Ranges all over the place. You can find, St. Louis is one of the most affordable places to have IP done. If you go to, I actually know of an attorney who's on the East Coast who actually charges $800 an hour.
So it's whatever the market will bear.
Yeah, right. There are different types of patents, and everybody kind of thinks of this first one, utility patents. That's what people tend to think of when they hear a patent, and that's the big one, a utility patent. Patents cover functional features of products and methods. There is something called a design patent. It's similar to a copyright. It doesn't function the same, but Annette talked about there are some things that you just can't copyright. Design is kind of the limbo between copyrights and patents. There are some things that you can get a design patent on that maybe you can't get a copyright on, and you can't get a utility patent on. Design patents cover the ornamental features of a useful good. So like, say, the outside shell of a car. Plant patents, that would be Monsanto and companies like that. It's a very, very specific kind of a small niche area in patent law. That you're only going to see certain companies. We're not going to really talk about that because it's just very specific. Provisional patents are a precursor to the big utility patent. It's sort of the waiting line for the patent office. You file the provisional, it just sits there for a year until they're ready for you to actually start prosecuting the actual patent. So what can you patent? That's probably the most common question I get at, family events or things. Oh, you're a patent attorney, right? So can I patent this? I got this great idea. There's a lot of things that you can't patent. Anything that's patentable has to meet this criteria. Utility has to be useful for something. That's a really, really easy bar. Just has to be useful. It doesn't have to be practical. It doesn't have to be profitable. It just has to be useful. There's plenty of patents that have never made a dime. Novelty. It has to have something new, right? That's also kind of a low bar. The big factor is what we call obviousness, which in the patent world doesn't really mean the same thing that it does when we talk about it in our day-to-day. Obviousness it's a very subjective test, and it goes something like this. If the invention has only obvious differences to one skilled in the art. Okay, yeah, that sounds like a lot of lawyer jargon. If you were in the business of making cars, let's say car engines, and you come up with a new engine, and all you did was say change the screws out, we're going to use bolts instead of screws. That's an obvious difference. It's not a patentable, distinct difference. Anybody that designs car engines know that you can use bolts instead of screws. That's the kind of thing that we're talking about with obviousness. There are some things, of course, that just aren't patentable. Yeah?
Does that apply to drugs as well?
Yeah, that's the same criteria no matter what product, no matter what method. Obviousness is really the big one it comes down to.
So if a drug that has reached its maturity under patent, the company goes back and slightly changes formulation, that's allowed, I've heard.
It depends. If you can show that it's patentable and distinct over what was done previously. Drugs can be different though, right? Because it's harder to show with a drug. Sometimes with drugs, just because this chemical over here is similar to the chemical here doesn't mean you're going to get the same product. I'm not a chemical engineer, I'm a mechanical engineer, so I'm relying on people that know to draft these applications. That it's kind of weird, just because this is similar to this, it might not be obvious, but that's the bar you have to pass. They will cite your own previous stuff against you, so that happens all the time.
But pharmaceutical companies, they patent their product, their generic, their chemical, whatever it is, by a generic name. And then they take the generic name and they use a trademark name that they put out there to market.
Well, trademarks is different, right?
I know, but that's what they do.
Well, correct. So you can, when a patent expires, and we'll get to that, patents for drugs, and they last 20 years from the date that you filed it. When that 20 years passes up, now drugs are a little different because there's some extra laws because it takes so long for them to go through the trials and all that, that the 20 years starts a little different because they have to deal with all that trial and medical, medical stuff. But when it expires, that's when it becomes generic. Now anybody can make it, right? That's where the trademark takes over as being an important asset to that company. Because even though there's a generic version of, and think of one. Tylenol, right. Tylenol is what, acetaminophen? So Tylenol is the trademark, and there's generic versions of that too. But a lot of people will buy Tylenol because of the trademark associated with it. They, as Morris talked about, they identify a certain quality and consistency with that product that they don't necessarily identify with the generic products. So that's why trademarks can go on forever as long as you keep using them. So that's why trademarks can be more valuable than patents, especially if the patent expires.
There's a company in this town that if you develop a drug, you go to it, and it's going to look at all the derivatives of it. They give you a list of them, and you go out and patent them without testing them or anything.
Well, patents don't have anything to do with the testing.
In other words, you don't know that it's valid or not.
Yeah, again, patents have nothing to do. The patent office doesn't care if your product works, whether it makes money. They just need those three criteria. Is it novel, is it useful, and is it not obvious? There are, and I'll get you an example. You'll see how it's kind of how this ties together soon. But there are some things that you cannot patent. You just cannot patent. It's just, you cannot do it. But these are the things that are. You have to have a useful process, machine, or composition of matter, which would be like a drug, right? So you can have products, and that would be something that has parts A, B, and C. It can be a method of manufacturing the device that has parts A, B, and C may be patentable. You may have a kit. If it's unique enough that these things, you'd never were to combine them to get this, make something new. And nowadays, right, you know, as the phrase goes, we're standing on the shoulders of giants. There's almost nothing these days that isn't based on something that already exists, right? We're always building on technology before. And so that doesn't mean that you can't patent something new. It just means that those pieces need to be combined in a new and novel, unobvious combination to solve maybe a new problem. There are things you can't patent. Like I said, you can't patent laws of nature. You can't patent gravity or E equals MC squared. That's just nature. You can't patent it. It just is what it is. Natural phenomenon. You can't patent lightning. You can't patent abstract ideas. That actually gets into more copyright. And recently there was some change. You can't patent human organisms, and so clones, right? That's not patentable because we don't want people to start patenting clones. And tax strategy. Yes, there was actually, that happened because of somebody. There was a tax attorney who wanted to patent a way to file taxes so that everybody in the world would have to go to him to file the taxes. So they had to actually say, no, we're not going to allow that. So there's an interesting distinction. Yes?
Concerning patents on drugs, hasn't that sort of been turned on its ear because the drug companies, after when the patent runs out, they don't go to generic. They have all kinds of bruises to keep the drug from going to a generic and lowering the price.
Well, from a legal aspect, once the patent expires, the company that's making it doesn't have to be the one that makes the generic product. The patent, the way a patent works, this is the idea, this is what the founders, why they put it in the Constitution. The idea is that you're making a deal with the government. The deal is you're going to write this patent. This patent is going to describe to everyone in public how you make it, how you use it, and the idea, and for that, for giving that up, they give you a monopoly for a limited period of time, 20 years, so that you can make money off of it. The idea is that if there wasn't an incentive, a lot of people would take their devices or ideas and take it to their grave. Once that person dies, we'll never know how they did it. All that technology is lost. And there's actually a lot of examples in history. You can go talk to your high school history professors and they'll tell you, I mean, the sacking of Rome and those kind of things. The Dark Ages was all about all that technology was lost. We had to recover it, start all over again. This is to incentivize people to disclose it, and once it's out there, other people can then build on top of it. And that's why you see it rising in importance, more and more people trying to develop new ways to do things based on the information that are in these patents. And that's the sort of the idea here.
Wasn't the time changed recently, extended from 7 years to 20?
No, it's always been, it used to be 20 years from the date that it issued. Now it's 20 years from the date of filing. It ends up being about the same practical sense. It just has to do with how the process, the application process goes. But yeah, it's 20 years. This is an important distinction to make. A lot of people think patents are, no, they cannot be renewed. There are no renewal of patents. They last, it's a one-shot deal. 20 years, and you can't repatent them. Once something has been patented, it's now in the public domain. You can never patent it again.
Can you alter it to get a new patent?
If you can file a patent with a distinctive difference that can be patented over it, that's novel, not obvious, then you can get a new patent on it. But it might be harder because that technology also already exists. Yes?
So isn't that pretty much what Procter & Gamble does with most of their products? Because I mean,
Well, again, that's what everybody does, right? Everybody knows what's all in the patent, so they're all trying to come up with the next product, whether it be drugs, whether it be TVs, whether it be cars. They're all trying to come up with the next patentable, distinctive thing to build off of what's already been done.
this Tide's like on its fifth newly invented Tide. They tweaked one part of the formula and added something that,
Yeah, and marketing is obviously different from patentability too, so.
they changed the formulation.
Yeah, so I mean, that happens all the time. Yes?
I'm confused with the slide that has 35 U.S. Code 101. Kit having parts A, B, and C. Where like the product has device having A, B, and C, is the distinction a kit is something that somebody would assemble?
It can be. Those are just examples of things that you might be able to claim.
Can you give me an example of a kit that I might?
Maybe like a kit car. You can buy cars that are coming, you know, assemble yourself.
Okay.
So once you assemble it, you know, it may be, that's what you need to have is the parts that are in there. Those are kind of hard to get. So you don't see kits a lot of times. It's usually the actual A, B, and C. But
Controls the genetic medicine.
what's that?
Controls the purity of genetic medicine.
Well, again, that's the FDA. Totally different government bureaucracy.
Trust the genetic medicine just as much as you.
Yeah, I don't know. That's FDA. That's the patent office doesn't get into any of that. Let me keep going here. I might be able to get to some of your questions. I don't want to. So this is a big thing to understand about patents is people think that a patent grants you the right to make and use the invention. It's actually the opposite of that. You're granted the right to exclude other people from practicing the invention. I describe it, I think a visual is sort of like a fence around your yard. You move into your home, you have a fence around your yard, you own everything within that fence. How you want to use it is totally up to you. But what you don't want is you don't want people just walking through your yard and using your yard for whatever they want. So it's your right, if you never want to walk in your backyard or make an invention or whatever, that's your deal. That's you can do what you want with it. If you want to sell that and let other people buy your house in your yard, you can do that. If you want to give people licenses to come and play on your yard, you know, in your yard, that's the same thing with patents. It's a fenced-in yard. And all patents are not created equal. Some patents have bigger yards than other patents. It depends how they're drafted by the attorneys and what has been cited against it and comes before. So that's sort of a important thing to understand when you're trying to learn about patents. This is an example of an actual patent, and you can see this one is a baby padding machine. Like I said, the patent office is not really curious or interested about whether this is going to sell. They just want to know whether it's novel and not obvious, and apparently they decided this was not obvious. You can see it's a device for patting a baby to sleep by means of periodic pats upon the rump or hind part of the baby. And this is the heart. When you look at a patent, if you get bored and have trouble going to sleep some night, I recommend pulling up any patent and reading it. We use a completely different type of terminology and language in patents that you would never ever use in a conversation. And it's actually, we're required to write this way. My English teachers would roll over in their grave. But we're actually required to write this grammatically wrong, inaccurate type of language.
So I can't apply for a patent just by myself? I have to come to an attorney?
No, you can. Any independent inventor can file themselves. I wouldn't recommend it to anybody because it's almost impossible to write a patent that meet all the, statutes and regulations that you have to do to get it through. You can file it, but then they're going to send you a response that says, you didn't meet 35 USC 102 and do this and do that. So it's kind of like you can write your own will too, but maybe that's not a good idea. In fact, although I think writing a will, you'd have a better chance of doing that properly than a patent. This is an example of a design patent. You can see it's a car, just the ornamental features. Design patents don't cover useful features, so it doesn't cover the engine or anything like that. Why get a U.S. design patent? Design patents only last 14 years, and they don't require payment of maintenance fee. Utility patents actually, once you get them issued, the costs don't end at 7.5, 9.5, and 11.5 years. It's not a renewal, but they do want a fee anyway. The U.S. Patent Office loves to have fees for anything they can attach a fee to, and that's one of them. This is an example in a patent. What defines the patent, the scope, the fence that goes around your patent yard, are the claims. That's that really, really weird numbered paragraphs at the end, and we really use weird language for that. And this is kind of an example of what, the optimist says glass is half full, the pessimist says the glass is half empty, the patent attorney says it's liquid H2O that bisects an open cylindrical vessel. And that's actually very accurate. That might be how I describe it if I had a patent. Patents are only good in the country that they are issued. There's no such thing as an international patent. You have to get it. Every country wants their piece of the pie, and you're going to have to pay everybody for each country you want protection in.
Does the patent office then determine or distinguish what can be patentable and what isn't?
They make the determination, yeah. You apply, and then over the course of that application, they determine whether it's patentable or not.
So they do all the research and say, yep, it's by itself, it meets all the criteria.
It's more of a collaborative process. They're sort of the judge and jury, you could say. You file for it, and they say, well, we looked and we think you made your fence too broad. You might want to make it a little smaller. So then we come back and you can amend it, make the fence a little smaller, and there's sort of a negotiation that happens, and you try to find how much of this is going to be patentable. And hopefully at some point you get to an agreement and the patent issues.
They know.
Well, they think they know. Patent attorneys that work with them on the other side tend to disagree with them a lot, because we're arguing to get much broader patents. It's their job to try to rein it in and make them smaller. And that's sort of the process. This is an example of a design patent. Design patents are very, very narrow. They almost have no scope. In that way, they're very much like copyrights, maybe even less. They're good for protecting things that look exactly the same, exact copies. But they cost a lot less than a utility patent, so it kind of works out. The Apple versus Samsung case was a recent one that was litigated, where Apple actually caught Samsung trying to infringe their design patent. And you can see the top one here didn't infringe and the bottom one did. You can see how close they were. Little bitty things make the difference in design patents because the scope is so narrow. Like I said, the utility patents are 20 years, design are 14 years. I won't go over this since we're running out of time, but this is sort of the life of what it takes to get a patent. From the time you apply to get it, to the time that it issues, and all the steps in between.
What is the patent pending length of time? Is that like the first year after you file?
Patent pending just means that your application is still pending before the U.S. Patent and Trademark Office.
Well, that period of time, you're protected, aren't you?
No. You are, you can't enforce any protection until the patent issues, because it may not issue. There's no guarantee that you're going to get a patent. You can apply for a patent and ultimately just not get it issued. If that happens, then no patent and there's no protection, and you're just competing with everybody else in the marketplace.
Because I've heard on the show, they say, well, is your product patent pending at least if you don't have a patent?
Right.
They ask if you don't have any protection.
That means that they know there's an application on file, and they want to know if there's any potential that they're going to get a patent there. once they know yes or no, one of those sharks, they're going to have their attorney look at that application, find out if it's really going to issue or if it's just, a waste of time and, that kind of thing. But
do they not even accept an application sometimes, or can anybody get an application and say, oh, my invention is patented?
oh, they'll take an application and money from anybody. I guarantee it. You can file an application and pay the fee, but it's up to them to decide whether you meet all the specifications and all that along the way. Which is exactly why you have to have somebody who knows how to write these things do it, because they're just such technical documents.
I understand when a patent is pending, nobody can look at what you're writing.
No, that's not true.
It's open to the public.
Well, it's only secret if you keep it a secret. If you go out there and show everybody, then it's...
No, but I meant the patent office wouldn't let anybody else.
Right, it's not disclosed until 18 months after it's been filed. So eventually it gets published. Last couple things I'll mention, because I know we're running out of time, is how do you infringe? Those claims at the end. To infringe, you do each one of the things that are in those claims. That's how you infringe. If you just don't do one of those things, you don't infringe. So if there's 20 things and you only do 19 of them, you don't infringe. You got to do all of them. And of course, everybody knows when you win a patent infringement suit, you can win lots and lots of money. And last couple things, I'll say some of the common myths. I can repatent a patent. No, you cannot. I can get a poor man's patent. I hear this one a lot. If you mail your idea or invention to yourself and then you're protected. No, it doesn't do anything. Other than waste a stamp. That's about all it does. You can't protect. The only way you can get a patent is filing in the U.S. Patent and Trademark Office and having them issue a patent. The U.S. PTO will stop people from infringing my patent. No, thankfully there are no patent police. They won't come knocking on your door. It's civil law. You have to file a lawsuit like any other type of civil law and enforce your own patents. And I'll stop there, and I'll be available for a little bit if anybody's got some questions.